Good morning, everyone. I'm glad to see that everyone decided to come back today. That's good. Okay, so this morning we're going to be talking about challenges, and as I'll discuss in just a few moments, this is one of those things where we see a fair amount of global convergence these days, but we also see a fair amount of differences in approaches. Or, in other words, the concept of providing an opportunity for disappointed offerers to challenge a procurement is increasingly common, but this is one area where we see a tremendous amount of diversity with regard to how different states approach the process. Okay, so this morning I'm going to discuss a number of things, but one thing that I found encouraging yesterday is we actually started getting some questions. So if you have specific questions, I can go in different directions, so let me know. But what I'd like to talk about today is I'd like to give you a sense of some of the differences in approaches in the language and the parameters that different states use. I want to spend a few moments talking about the underlying purposes for why we've seen the consistent growth around the world of these types of challenge mechanisms. This is for two reasons. First, we all have our own concerns as to whether it's a good idea. But in addition, what we found, even in the states that have been doing this for many, many years, there will always be pressure to eliminate these opportunities or constrain or limit them. So I think it's important as a government official to form your own opinions as to how or why these are a good idea, or if you're not convinced, to think about how you can change the system so that it meets your needs without being overly burdensome. All right. Most of the time that I'm going to spend today will be talking about different ways that you can design these systems. And again, keep in mind that different countries around the world have done this very differently. So I'm going to break it down into elements or considerations, and then I'll give you a number of examples later, particularly with regard to different models around the world. Another thing that I'd like to do is spend a little bit of time talking about some of the more common problems that we see with regard to these mechanisms. For many of you, this may all seem extremely mundane and familiar. For some of you, it may be new. Again, I'll be going in a fair number of different directions, but if something is of particular interest to you, please stop me so that we can discuss it further. Okay. Let's do the big picture first. What are we basically trying to do, or what do these challenge mechanisms hope to do? What's the tool itself being used for? So, briefly, it's an opportunity for someone who has submitted a tender or a proposal or a bid for a government contract who didn't win. So we often use the term disappointed offers. You competed and you lost. So now you have the opportunity to fix that problem. It's not necessarily based on the idea that you lost. The point of the exercise is to fix problems or anomalies in the process, or to identify and eliminate any unfairness or inequity. One very brief point, and this is a little bit small but important. The challenge mechanisms in countries are basically available for both domestic and foreign offerors. So, if you have a Brazilian firm competing for a contract, they would have the same right to bring the challenge as a Costa Rican firm. I only mention that because one thing that I will not be spending a lot of time on today is there is an entirely separate system in Geneva under the World Trade Organization Government Procurement Agreement, where states can challenge other states because they don't believe they're living up to their agreements under the Government Procurement Act. That's not what we're talking about. So state versus state challenges in the international tribunals in Geneva is entirely separate. The only thing that we're focused on is the actual contractor challenge to the award of a contract. Okay, now here it gets fun. It is amazing to me in 2019 that we still don't have a common language or vocabulary or vernacular on these topics. Excuse me. So what we see is, even though we're describing something very, very similar, there are different labels or titles given to these tools in different countries. The United Nations model law uses the term challenges, and frankly, it's a very logical term. Someone who submitted an offer, didn't win, they challenge the way the process was executed, and that's the legal remedy that they're seeking. The World Trade Organization Government Procurement Agreement, the WTO, used a different term. They called it a domestic review mechanism. Now, frankly, they're the only organization in the world that uses that phrase. But remember, they're using that phrase because they also have a state-to-state challenge related to procurement. But no one else worries about that. But if you're looking for the basic challenge rules under the WTO GPA, they call it domestic review procedures, and I'll talk about that later. All right, to make it more confusing, the European Union, which was a little slow to come into the game, when they consolidated or tried to standardize the approach throughout Europe, they used the term remedies. As an American, this makes no sense to me, but that's irrelevant. They use the term remedies, and everyone in Europe knows exactly what they're talking about. In the United States, we tend to use the word protest. I competed, I didn't win, I protest that procurement. The courts, however, have frequently used the term disappointed offeror litigation. I was an offeror, I'm unhappy, I go to court, or I sue, or I litigate. We call it disappointed offeror litigation. We also call them bid protests, but this is actually not a very good term because a bid protest could also apply to a proposal or a tender or something else. But again, we're all talking about the same thing. Some states also use the term complaints. I'm complaining about the procurement process. On the one hand, none of this matters. The only reason that it could matter is we live in a world of the internet, and we solve many of our problems using Google or Firefox or search engines. And it's important to keep in mind, if you're trying to compare the various tools, this is an area where they'll be under different labels. But the most important thing I want to say about all this is these are all doing the same thing. Different states, different labels, different words. But that's different from contract disputes. So I'll spend a little bit of time just in a few moments distinguishing the universe of what we're talking about and what we aren't. Do we have another microphone, please? Hello? Somebody have sorry. Well, I have a question here. So. It's coming.
Aló, buenos días. Buenos días, doctor Steven. Buenos días a todos los colegas. Doctor, dentro de esas diferentes identificaciones de inconformidad en la contratación en cada región, es donde me parece que identifico que a la par de esas está apelación. De acuerdo, apelación está incluida en una de ellas o esa parte, que es la forma que yo diría que se conoce en Costa Rica. Le dan la contratación a otra empresa y yo apelo. Ahora bien, discúlpeme que quiero incluir de una vez, para aprovechar la oportunidad, el hecho de, yo soy una empresa privada, pública, tiro un cartel, hay 3 oferentes, y en el cartel hago descripciones de detalles de cómo quiero el artículo, que de por sí ya lo tiene un oferente, para que lo gane ese oferente. Ejemplo, pido carretillos verdes y rojos, que solo lo tiene ese oferente, o sea que ya lo ganó. ¿Me explico? ¿Cómo se puede hacer para hacer un poco más neutral? Pero además la parte de apelación, que era lo que quería, ¿dónde quedaba?
Okay, so I think I want to give a two-part answer to that. What you find is different states have different appellate procedures around the world. Some states permit the challenge and an appeal. Some states permit 2 tiers of appeal. Some states permit a challenge with no review whatsoever. Okay? So this is entirely dependent upon the legal regime of the individual state. On the second question, I apologize. I'm not sure I fully understand what you're asking as to whether it's the difference between procurement design and, for example, specifications and evaluation criteria, or actually the challenge itself. So I think you may have lost the microphone, but I'd love some clarification. Oh, the microphone's right behind you, please.
Gracias. Decíamos ayer que de las cosas que interesaba por la creación de la contratación administrativa es por la gran cantidad de dinero que se necesita mover, ¿no? O sea que lo importante de la contratación administrativa es porque son las grandes cantidades de dinero para que sean de bienestar a la comunidad de la mejor manera, sin corrupción. Pero lo que quiero decir, tal vez de forma muy popular, es, yo soy de gobierno, hago un cartel para licitar un servicio o producto y de una vez describo las características de una de las empresas que va a concursar. O sea, ya estoy montando la corrupción, ya la estoy haciendo. De fijo esa empresa lo va a ganar. ¿Comprendido?
Okay, now I think I understand. I'll talk in just a few moments about different types of issues that you can challenge. What I hear you referring to is when the government creates a restrictive opportunity, or in other words, where they don't permit firms to compete by drafting the solicitation such that only one firm could win, or it's clear who's supposed to win, most states will permit someone to challenge. This is a critical distinction, but somewhat sophisticated if you don't really understand procurement. We have what we call pre-award or pre-solicitation challenges and award or challenges after the award. Most people, when they hear challenge, they think, I submitted a tender or a bid and I lost, and I want to challenge the award. The better regimes also permit challenges to the solicitation or the request for tenders before the tenders are submitted. And that permits us to fix mistakes earlier in the process. So the question you ask is a very important one, and we'll talk more about that a little bit later. But now, let me go back to the other point. So remember here, I said that all of these things are the same, just different words, but that's different from something that goes wrong that we call a contract claim or a performance issue. So, we're in a legal building. There's lots of lawyers in the room. There's lots of different types of litigation involving government contracts that is not part of what we're talking about this morning. The biggest one is the issue of contract performance disputes. In the United States, we also have a specialized set of tribunals with expert judges who understand government contracts who do these issues. In most countries around the world, however, contract performance disputes go into the civil law courts, or they go to the normal courts of general jurisdiction. Some states use arbitration, some states use other mechanisms. But in our experience, it makes sense to also have a specialized tribunal. But again, this is separate from the kind of challenges we're talking about this morning. Now, these are a number of issues that tend to arise in government contracts. Am I good? Yeah. Judges that understand government contracts will give more consistent decisions, and that's important. But the point that I want to make here is that in a challenge or a protest, we're not going to be talking about anything that happens after the contract is awarded. That's a different legal regime. Now, since I'm here, just some other examples of unrelated legal regimes. Disputes between prime contractors and subcontractors. As many of you know, we talked about supply chain yesterday. Just because the government has privity of contract or a contract with one contractor doesn't mean that that contractor doesn't also have subcontractor or supplier agreements with other firms. As a general rule, the government has no relationship with the subcontractor, and these disputes tend to play out in other tribunals. Another massive issue, since we talked about corruption control yesterday, there's obviously a lot of litigation involving fraud and corruption and other improper activities. We tend to distinguish these between civil disputes, where only money is in dispute, and criminal actions where people can actually go to jail. But these also are going to take place in different tribunals. And then finally, we won't talk about this today, but another type of tribunal or another type of remedy that's very common in government contracts is states can basically exclude or suspend or debar, or as we say, blacklist firms so that the government doesn't have to do business with them in the future. That, again, is a separate tribunal from what we're going to be talking about today. So again, today, we're only going to be talking about challenges to the actual award of the contract or anything leading up to the award of the contract. Okay, now, very briefly. In the last 30 years, we have seen most states and all of the major international organizations agree that having some kind of a challenge mechanism makes sense. But it was not so long ago that that was not the case. We had them in the United States, and some of the major states had them, but the United Nations didn't permit challenges, and many industrialized countries didn't think this was a good idea. But this has changed in the last 30 years, and now more states have challenges than don't. But as I'll discuss later, what we're seeing is we're constantly changing or evolving or tweaking or basically modifying these mechanisms, and therefore there's a consistent discussion, particularly among legislators, as to whether these are a good idea or a bad idea, whether we should do more or whether we should do less. So I just want to briefly summarize some of the common arguments for why we have these regimes. And as I say here, this is important because we can discuss why I should do this, but what we do literally every year in our legislature at home is we defend against the arguments that we should eliminate them. Many of our largest procuring agencies go to their legislators every year and say, we shouldn't have bid protests in my agency because my work is so important that I shouldn't be challenged. And so we literally fight this battle in our legislature every year, and we've been doing this for more than 70 years now. So again, just some things to keep in the back of your mind. All right, first and foremost, the general argument for having a challenge mechanism is it helps you ensure that people follow the rules. So it avoids or prevents people violating the rules. I can tell everyone what the procurement rules are, but if there's no mechanism to challenge it, it's hard to ensure that everyone behaves correctly. But frankly, I think a better argument is that it's good for the system and it's good for the government. Let's be honest. The public doesn't always trust the government. The public doesn't always trust individual government officials. Many people in the private sector often think that someone in the government is up to something, that they're trying to get around the rules, that they're favoring a certain firm. If we want to maintain public trust in our institutions, if we want people to believe that we're spending procurement dollars wisely, it makes sense for us to have an opportunity for people to come and challenge what we do so that we can convince them that we are in fact operating in a fair and transparent and competitive way. The other thing, and this is a little bit more subtle, study after study shows that a good challenge regime ultimately increases competition. All right, let's imagine you have a big procurement and a large sophisticated firm from Brazil or Chile or Mexico comes to compete for your contract. And they lose, and they don't understand why. You don't explain to them why they lost, and they can't challenge it. They assume that they were excluded because they're a foreign firm and that they never had a chance anyway. What happens? Will they come back and try again? Probably not. The domestic firm knows that they now have less competition. Their prices go up. They worry less about quality. However, if the Mexican firm loses and you explain to them why they lost, and they can bring a challenge and you show them that their competitor's proposal had a better pricing structure or was more responsive to your needs, then they can learn from that and they say, I understand the process now. They come back and compete in the future. Prices go down, quality goes up. Every time someone spends their money preparing a tender or an offer for you and they leave angry, you increase the chances that they're not coming back. And that's exactly what you don't want. It's important for them to believe that they're being treated fairly and they're given a fair opportunities to compete. All right, another one, and remember we talked about trade yesterday. Many states have found that if they want to be players in the international trade community, they have to do this. This is a basic World Trade Organization Government Procurement Act requirement. So if you're at all interested in being part of that global trading community, this is something that makes sense. And of course, in this region, there's the North and South American trade agreements and the regional trade agreements. Most of the regional trade agreements similarly have requirements for tools such as this. But let me suggest another one. And this, again, in a group of attorneys is pretty easy to explain. But what we found over the years is that protests are a very effective way to delegate oversight to the private sector. Now, we haven't talked a lot about oversight, but to the extent that we appreciate your government spending a lot of money through procurement, we're worried that people are going to behave badly. One solution is, for every procuring official that I have, I could assign an auditor or a policeman to follow them around all day. This would obviously be very expensive. It would also be extremely boring for the auditors and the policemen. But we can only afford so much oversight. What we've learned over time, however, is that no one cares more about how the government behaved on an individual procurement than the firms that would like to win that contract. So the incentive of the private sector to ensure that the government follows the rules are highest when they're investing their own money in competing for that contract. So in other words, they care more about how you behave than anyone else. So in effect, what we do is we say to the contractors or the prospective suppliers, you're interested in the outcome here. If you think you were treated unfairly, you can come and challenge me, and in effect, you're doing me a favor by providing me with oversight resources that I didn't have to pay for. The beauty of this is if all of the potential suppliers or contractors think the government behaved well, nobody has to pay for any oversight. But when the government does behave badly or make mistakes, the people who have the greatest interest and are best situated to find the violations, the ones that have the incentive to fix the problem, they can bring a very specific challenge and we can review it. So we often say that these delegations are in effect making the contractors private attorneys generals. We're asking them to help us with our oversight mission by empowering them to challenge us when they think we've acted inappropriately. Okay, changing gears a little bit. So if we agree that we're going to create one of these mechanisms, and if we're constantly thinking about how we can make it better, it's important to keep in mind what we want out of the system. So, first and foremost, we're trying to create a place or a forum or an institution where people can bring their challenge. So they're going to hear the complaints, but they're also going to give some amount of relief or a remedy where there's been a problem. So think of this as a structural expectation. One of the things that we want out of all this is once we create the forum, we want it to help us provide oversight and accountability. In other words, we believe that if the system works, government people will do what they're supposed to, and the system will be more reliable. There will be fewer problems. In addition, what we're in effect doing is expanding our transparency. We always talk about transparency in public procurement. I have to tell you when I'm going to compete. I have to tell you the outcome of my contracts. But there's a transparency value in telling the disappointed offerers why they lost or how they were beaten, and also telling the public when we've made mistakes. This is kind of a human nature issue, and I'll come back to human nature a little bit later. Most of us don't like to admit they made mistakes. I know that my children never admit they made mistakes. But governments are always worried about letting their weaknesses show. I don't want the public to know that some of my people behaved badly. That's exactly backwards. It increases confidence in the government when the government provides an opportunity for someone to identify mistakes that the government has made and then tells the public, we made a mistake, here's what we did wrong, and here's what we should have done. So it increases confidence by having increased transparency. And one thing that I'll talk a little bit more about later with this transparency is that the best challenge tribunals publish their decisions and explain what happened, whether the government behaved correctly or whether the government behaved incorrectly. So there's a lot of learning there, and these are very valuable tools when you're training procuring officials. There's nothing better than a case study. I can tell you what the rule is, but it's easier to remember it if I show you when the rule was applied correctly or when the rule was applied incorrectly. Okay, but here's the biggest challenge, and we'll talk a lot more about this later. If the government permits firms to challenge the awards of a contract, it's going to slow the process down. It's going to cost the government money. It's going to cause disruption to the process. So in order for the system to work, it has to do all of these things without permitting the process to grind to a halt. So we need to constantly balance how much due process, how much in terms of remedies, and keep the process moving along so that we can be relatively nimble and quick and efficient because we have to have our contracts awarded. Okay, I'm changing gears again. I want to talk a little bit about how many different options you have in designing your challenge regime. And I know that some of you are thinking, we have a challenge regime. Why are you telling me how to create a challenge regime? What we have found around the world is they are constantly being changed and improved and tweaked. So many states have multiple challenge regimes. Many states add or subtract remedies over time, and they change procedures as best practices evolve around the world. But the key point here is it's one thing to create it, it's another issue to manage it. I can create a forum, but if it isn't working or it's not meeting my needs, I need to be thinking about how to improve it so that it does meet my needs and doesn't stop me from getting my work done. One of the great things today is there's much more global conversation where we compare and contrast and share lessons learned and experiences saying, oh, I like that aspect of this system, I might try it. We've been doing this and it didn't work, I may try what that country did. And I'm going to give you a particular example later from the European Union, which you may find to be incredibly helpful in the future. Okay. We're not starting from scratch here. But if you were creating a challenge mechanism from zero, if you wanted to create a new one, this is a short list of the questions that you might ask. Another way to think about these questions is, to the extent that I am familiar with a particular challenge forum, how might it evolve or change over time? Or where might I expand it or rein it in or tweak it over time? All right. The first, and the one that most governments start with, is where. Should it be judicial? Should it be administrative? Should it be handled by the private sector? There's many different ways we can do this. And as attorneys know, we have courts, we have administrative tribunals, we have arbitration, we have mediation, we have alternative dispute resolution, we have private resolution. There's many options, and there's no specific rules as to how to do this. Next, this goes back to the question that I was talking about at the beginning. Do you want to be very encompassing and accept a lot of challenges, or do you want to be a little bit more limited? And I'll talk about a number of ways that can be defined, but there are policy decisions associated with how broadly you want to permit the challenges to be, and that's an issue of jurisdiction. The next issue is who can bring the challenge. The most common thing you're going to hear in this discussion is the concept of the interested party. Which firms have a legitimate business interest in the outcome of this procurement? For example, if you are not a manufacturer that produces the good that the government's buying, as a general rule, we're not going to permit you to complain about this procurement. If you don't like an award of a contract, but you didn't submit an offer or a proposal or a tender, I'm not going to permit you to complain because you aren't interested in the outcome. Now, this is interesting because many civil society groups think that the public should be able to bring complaints about the procurement process. As a general rule, we are not going to permit that. This is very, very much focused on competitors or potential competitors. All right, a next one, and there are examples all over the world. How much time are you going to permit someone to challenge? We want the process to move along, so if you didn't like the award, do you have to challenge it within 24 hours, a week, 10 days, a month, or a year? Around the world, we see the general time frames to be a week to 10 days, which is pretty quick, but I'll give you some examples later of much longer time periods. Similarly, there's the issue of how much time to start the challenge, and then there's also the issue of how much time the tribunal gets to resolve the challenge. And we see a fair amount of variation there as well. Okay, once the challenge comes in, how much evidence should be available? Many of these fora, because they have to work quickly, limit the amount of evidence they can look at to what we often think of as the contract file or the administrative record. Should you have live witnesses? Should there be cross-examination? Do you want to permit discovery? Differences there. Okay. The next is the issue of what we often think of as the interim remedy or procedural relief. If I award a contract to your competitor and you bring a challenge, if they can complete the contract before your challenge is decided, there's not going to be much of a remedy left for you. So it's extremely common in procurement to stop the procurement while the challenge is being resolved. We'll talk about the issue of the stay or the freeze or the hold or the standstill. But most countries have at least some time period where everything stops while they're reviewing the challenge. And then the question is, how often do we want the disappointed offeror to win? Or what should the standard of review be? Or what's the burden of proof? I will tell you one thing to keep in mind. The closer that calculus gets to 50%, the more difficult it gets to ever get your work done. Because anytime the private sector figures out that they have a 50-50 chance of winning a challenge, they realize that they should almost always roll the dice because the odds may be worthwhile. What you don't want is to have a system where I award the contract to firm A, that's challenged, and I award to firm B, at which point firm A brings a challenge and it goes back to firm A. We don't want to go back and forth. So we want a relatively high bar, or in other words, a high standard or burden of proof in order to prevail. And then the question is, what type of relief should be available? Do you get the contract? Do you get money? Are there other punishments or the like? All of these things are, frankly, different in different states. Okay, let's take a look at some of them. Let's start with the forum in terms of the basic approaches. For the attorneys, this shouldn't be any surprise. You basically have a few different approaches, and what you'll see is that some states do all of these. Of course, you can just let the challenges go to the courts. Some states do this, but frankly, this is a relatively rare solution. Most states understand that courts of general jurisdiction, judges, are not very good at this type of work. They don't know enough about procurement. Their dockets are busy enough that they can't move very quickly, and the normal approach to litigation in the courts is not consistent with what we need for these processes. One of the most popular around the world are what we think of as specialized administrative tribunals. And all of our countries have different administrative law processes, but the beauty of the administrative tribunal is I can populate it or staff it with experts. I can have people resolving the disputes who understand procurement, who understand business, who realize what the issues are and appreciate the need to keep the world going. Another approach, which we often think of as a decentralized approach, is to actually let the challenges go to the contracting agencies or the ministry or the department that's awarding the contract. In other words, if you're awarding the contract, you would receive the challenge. There are advantages and disadvantages to that. So again, there are many reasons to look at models from other countries on any of these considerations. But let me say this. What we've learned in the last 30 years is that this issue is much less important than this issue. Where you do the challenge is less important. What matters is what the forum does when they get it. One of the most important issues is independence. It is critically important that the party getting the challenge is not afraid of or intimidated or beholden under the government. In other words, if the challenges go to an adjudicator who believes the government is always right and the private sector is always wrong, the system won't work. So they need to be independent of the government. I'll give you some examples later on that. Next, and I think this is very, very important. Every study around the world has reminded us that if the adjudicator doesn't understand government contracts, they're not going to be able to do this. Procurement is different from private business. And so having some amount of procurement expertise is important to make these systems work. Some amount of ability to enforce the remedy. If I create a forum and the forum has the power to give a remedy, but the ministry or the agency or the department doesn't have to follow that recommendation or the order, there's no point in having the exercise. So this is also quite important. And then finally, the issue of speed and cost. These systems only work if they work quickly. If the system doesn't work quickly, the government can't award contracts, it can't perform its missions, it can't do the things it needs to do to govern. In addition, we don't want to create a tool that's so expensive that no one wants to use it. And we have examples of that too. So, these are all choices, but regardless of which one you choose, these are the things that are really important. Okay. Now, here I go back to the point that you asked a little bit earlier. When you design the forum, one of the issues you have to ask is, what can the private sector actually complain about? Around the world, we tend to break this into two categories: pre-award, before the award of the contract, or after the award of the contract. The ones that are the most common or easiest to understand are these. I am complaining because I submitted a tender and I did not win. I think my tender was better than the winning offerors. That's the classic challenge or bid protest. So let's put that aside just for a second. The ones that we often don't think about, but these are the ones that will help your government the most, are when you welcome the early challenges. For example, I just found out about this potential award. That was never published on your website or in your journal. I can't compete if I don't know about it, so I want to bring a challenge because there was lack of notice. That's great, all right? And what that does is it basically reminds the government how important it is to follow their rules with regard to notice of opportunities. Next, and I think this is what the question earlier this morning was about. I just read the invitation for tenders or the request for proposals, and the way that it's written, only one firm is going to be able to compete. Or the way that it's written, you've excluded a technological solution that you may not have been aware of. Or what you're doing is you're locking yourself in to an expensive solution while there might be a less expensive solution. So these are very important too. Another one, and this is tremendously important, I'll talk later about friendly challenges. One of the biggest benefits of having a challenge system is when you permit the private sector to tell you when they don't understand your solicitation. Okay? I'll talk more about this afternoon, but you will be surprised by how frequently the government does a lousy job explaining to the private sector what they need. The government doesn't always know how to talk to the private sector. So if the private sector reads the solicitation for tenders and they don't understand, they can come back and say, you said this, but you said this. I think that's inconsistent. Do you actually mean that? Now, I'll talk later about the fact that one of the reasons this is so important is in many countries, if a potential offeror calls the government official and says, I don't understand the solicitation, the rules require the government official to say, I can't speak to you individually, I can't give you an unfair advantage. This is an open forum for the offerers to basically say, your solicitation doesn't make sense, I don't understand, it's internally inconsistent. And then finally, if, for example, you have tiered evaluations, you receive the proposals, you create a smaller or a competitive range. If I'm eliminated from the competition at any point during the process but before award, it's better to have that challenge early on than having to go all the way back later. All right. Now, as I mentioned earlier, very common, any complaint about I didn't win because, okay? The strongest argument there is I didn't win because you didn't evaluate the tenders the way you said you were going to evaluate the tenders. Or in other words, you said you were going to award the contract based on low price, but when you saw the offers, you saw another solution that was better, that cost more money, and you chose that solution. I also had a higher quality solution, but I didn't offer it because you told me that you wanted a low price solution. So if you don't follow your evaluation criteria, I can challenge that too. The last, and this is very, very important, most states, for most serious procurements, have some form of debriefing or explanation for disappointed offerers. I just awarded the contract to your competitor. You didn't win. If you want to know why, you have 5 or 10 days to come in, and I will debrief you or explain to you why you lost. In the last 30 years, this has been one of the most interesting lessons learned. In states that give quality debriefings, they have fewer challenges, better competition, and higher private sector satisfaction with the system. In other words, even though the government generally does not like to explain to losers why they lost, it is typically worth it for the government to explain to disappointed offerers why they were beaten or how they can improve in the future, and that tends to give them better competition over time. However, anything they learn in that debriefing may prompt a protest if the government explains that they did something that was inconsistent with their original solicitation. Short answer is lots of options here. Okay, now, remedies. If you have a challenge mechanism, no one's going to use the challenge mechanism if there isn't a remedy they want. But the diversity of remedies around the world is extraordinary. The most common remedy in the world for procurement is what we think of as a procedural or an interim remedy. And as I mentioned earlier, that is, when you file your challenge, everything stops until the challenge is reviewed. Some people call it a freeze, some a standstill, some a stay or a suspension. As I'll talk later, this may be for 10 days, 100 days, 6 months, a year. I think a year is really a long time, 6 months too. Around the world, most stays are between 10 days and 3 to 6 months. But most are less than 3 months. We want the process to move quickly. All right. The remedy that is also very, very common, and if you think about it, it's a logical remedy. If the government made award improperly, then that award is canceled, and the government has to go back and start over. Conversely, one of the least common remedies in the world is direct award. As a general rule, most states do not permit the forum to say, the government awarded the firm A, that was wrong, they must award to firm B. As a general rule, we don't want the adjudicators to be making business decisions for the government. So, it is far more common to have the remedy be, I terminate the contract that was awarded, and then I go back and I either resolicit or reevaluate or renegotiate. But we generally do not permit the forum itself to say, you must award to the disappointed offeror. Okay. The other issue is money. The most common monetary remedy in challenges around the world is what we refer to as bid and proposal costs. Now think about this for a second. One of the most common mistakes that governments make, and in fact, one of the worst attributes of public procurement officials around the world, is they do not appreciate the resources of the private sector. Or in other words, they do not respect the money spent by the private sector competing for their contracts. Think about this. You're a government official and you write a lousy solicitation that doesn't make any sense. Firms spend hundreds of thousands of dollars, maybe millions of dollars, preparing a tender. But they never had a chance of winning because you didn't actually explain what you were going to do. Why should the government be able to waste the private sector's money like that? So, when the government makes a mistake in the process, one of the most common remedies to a disappointed offeror is to say, you can't win the contract, but I will reimburse you for the money that you spent competing for the contract that was wasted because I made a mistake. Okay? Very rarely does it make the contractor happy. They don't get what they wanted. They wanted the contract. But it at least reduces the harm to the contractor. So, the concept of reimbursing the firm for their proposal costs is relatively common. The much more controversial one is lost profits. As the attorneys in the room know, in a contract dispute, the most common remedy is what we call anticipatory damages. I want to put the non-breaching party in the position they would have been in had the contract been fully performed. How much profit would I have made if I had gotten that contract? This is a very popular remedy with the private sector, but it is not a common remedy in bid protests for a couple reasons. First, it's very, very expensive. Second, it's speculative. Just because I submitted a proposal or a tender doesn't mean I could have actually done the work, nor does it mean I could have done the work for the amount of money that I offered. There's the distinct possibility that I intentionally offered on the contract with an unreasonably low price because there was some other benefit to me of getting that contract even if I lost money. This is a very important concept, which I'm sure you're all familiar with. But remember, in government contracts, it is very common for firms to be willing to take contracts that are not profitable to them. There's a lot of prestige associated with doing a big government contract. I built the big highway in downtown Lima. That helps me compete for other contracts around the world. So it doesn't make any difference if I lost money on that contract if I then get other big contracts elsewhere. So as a general rule, we do not see lost profits as a common remedy. One other point, one thing that we've learned around the world is when we have this as a remedy, it is granted very, very rarely, and we also see less litigation. But again, that's a little bit more complicated. Another potential remedy is attorney's fees. You submitted a proposal, I behaved badly, you had to waste your time challenging me. In retrospect, I shouldn't have done the procurement that way, so I'll reimburse you for your attorney's fees. It's not that much money, and again, most contractors aren't going to be excited about that, but these are the common monetary remedies. Again, around the world, the most common interim remedy is the stay, and the most common ultimate remedies are termination and resolicitation. Okay, now, timeliness. If I award the contract on Friday, how much time should the disappointed offeror have to bring the challenge? This can go both ways. On the one hand, it's fair to give the private sector a reasonable amount of time. Having said that, the more time you give them, the later they protest, the more it slows down the process. I think if you did a survey around the world, most states permit disappointed offers to have 7 to 10 days between when the award of the contract is made or when they receive notice of adverse agency action. In other words, when they learn of the problem. Some countries only provide 3 days. There's no necessary rule on that. But again, keep in mind there's a certain advantage to the period being short, but we don't want it to be too short. Another issue is most states are extremely draconian or strict or firm on the deadlines. In other words, if I say you have 10 days to bring a challenge and you bring a challenge on the 11th day, should I let you have a little bit of flexibility there or not? The downside to the flexibility is that people take advantage of it. The benefit to the flexibility is sometimes you may find out about some really big problems that you wish you had been able to solve. Okay, now, here it gets really complicated. regardless of when you permit the firm to bring the challenge, how much time are you going to permit the body or the forum to have to resolve the dispute? In the United States, we use about 3 months, 100 days. Some states, 30 days. In Europe, there are some states that permit 6 months. There are some states, particularly in Africa, that permit as much as a year. Think about that for a second. I award a contract today. You can bring a challenge within a week, but I may not resolve that challenge for a year. How do you get your work done? So as a general rule, I think you need a relatively short period of time, but the more time you give, the more disruption you have. The less time you give, the harder it is for the forum to do good work and to have a fair litigation. And frankly, if you think about it, if you say to the private sector, you have to bring a protest within 10 days, and then the adjudicatory forum has to resolve the case within 2 weeks, they think, but they're never going to get all the facts within 2 weeks. It doesn't necessarily give them enough time to make a good decision. So the question is balancing so that you don't slow down the process, but you have a meaningful review. Again, I think around the world, 30 to 100 days is common, but again, everything from a couple of weeks to 6 months you'll find around the world. All right, a couple other issues to keep in mind. Personally, I agree with those states that publish the decisions of the tribunals, and these are not summary decisions, they explain what happened. In other words, this was the contract, this was the challenge, here's what actually happened, here's our decision, and why. This is incredibly important because from a learning standpoint, your procurement officials read these decisions. They learn what mistakes others made. They learn what mistakes to avoid. They're also extremely useful in training procuring officials. And the states that publish the decisions frequently find that these are very, very valuable training materials. Having said that, a lot of times what we're fighting about is sensitive business information. So oftentimes we redact or excerpt out some of the proprietary information. I think one of the other questions from this morning is the issue of appeal. Many states permit some appeal. And the value of the appeal is we want to make sure that we have credibility in the system. The flip side to that is if all of the decisions get appealed, it slows the process down even more. All right, changing gears. I want to say just a few words about culture and the challenges that states have faced in creating these systems. In other words, just like rules, you could copy somebody else's tribunal system. The question is, how do you make it work? All right, first and foremost, perception of the rule of law. If the private sector in your country doesn't have faith in your legal system or your tribunal, this isn't going to work. One of my all-time favorite experiences with this, you may recall I mentioned yesterday, we began working with the Chinese government 20 years ago in building their procurement system. And we had a discussion like this about these protests, and I got a question from one of the Chinese officials that said, who pays the judges? And we said, the government pays the judges, but they're independent. And they were working through an interpreter, and there was a brief pause, and then they all burst out laughing. And for the rest of the afternoon, I had a room full of American attorneys, and we argued with the Chinese about having a credible, independent judiciary. But at the time in China, even among government officials, there was no confidence whatsoever that you could have an independent judge paid by the government. That's a cultural issue. They've come a long way in 20 years. But this is really important. If the public doesn't believe that the legal system works, there's not going to be a good challenge mechanism. So you have to have respect for the tribunals. And similarly, you have to be willing to litigate. In the United States, in the business community, we have a term that we often say, you don't bite the hand that feeds you. Or in other words, often you don't litigate or sue your customer because you don't want them to stop doing business with you. This is very important. It is incredibly important for the government to convince the private sector that if they bring a challenge, you will not punish them. You will not blacklist them. You will not avoid them in the future. That this challenge system is something that you believe in, that you welcome their help in terms of oversight, and you are not going to punish the firms that bring challenges. If you can't do that, the firms will never bring the challenge because they'll be afraid of being put on a blacklist. Now we go back to the point I was making earlier. It's not where the forum is, it's who makes the decision. And it is a huge capacity issue. These systems only work if the decision makers understand procurement, are serious, thoughtful, fair, and independent. They have to be knowledgeable, the public has to trust them, respect really helps, and they have to be independent. This is hard. What some states have done when it is not easy to create this group is they have used panel systems where they mix and match different people from different groups so that they can get a general group that is independent. But the best systems have expert adjudicators who have proven to be independent. Similarly, and this goes back to the point I was just making, when the government is litigating in these challenges, it is important that they respect the process. If the government attorneys communicate to the private sector and to the adjudicators that they don't respect the challenge, that they don't respect the private sector, the system isn't going to work. So the government has to cooperate, they have to respect the adjudicators, they have to do what they're told to do, they have to meet their deadlines, they have to produce the documents. The system only works if the government cooperates. All right, now, let's be honest. We have decades of experience with these systems around the world. Almost every system has the same problems. One of the things that we all worry about, there's no two ways about it, is these systems cost money. If you don't want to spend the money on it, it won't work. If you don't have the money, it's a problem. But in addition, what we worry the most about is that there are perverse incentives for the private sector to bring vexatious or frivolous or predatory protests. I'm mad at the government, and so I'm going to waste the government's time or money by bringing this challenge. I'll talk a little bit more about how we avoid that, but this is a risk that we always run. Another thing that we have to watch for, and this is extremely problematic, we want to avoid a situation where government officials send a message to the private sector that if you bring a challenge this time, I'll make a deal with you in the future. We have to keep our procurement process clean and open. All right, at the other end of the spectrum, one of the biggest problems that we have with a good challenge system is risk aversion, overcompliance, or fear. In the United States, there's nothing a procurement official wants least than to have a challenge of their procurement, and even worse, to have their name mentioned in a published decision that's going to be used as a training example later. So what happens sometimes is government officials don't make good business decisions because they're so worried about the rules and the challenges that they don't get good results for their customers. This is a training and a management and a supervisory challenge, but it's a very, very important one. We don't want our procedures to become unnecessarily bureaucratic just because there's a fear of a protest. Okay, now, to the extent that we're worried about these vexatious or frivolous protests, there's a few pretty common approaches to them. Some are better than others, but many states have experimented with all of these. One thing that you can do is you can have a high filing fee. The filing fee disincentivizes firms from basically just trying to punish the government with their protest. The problem is filing fees also discourage legitimate protests. So I'm not a big fan of anything other than a nominal or a very low filing fee. We can have penalties or fines for frivolous protests. In other words, if you bring a protest and I figure out that you only brought the protest to irritate the government, I may basically impose monetary penalties on you or tell you you can't bring protests in the future. Many countries around the world basically say, you can bring your protest, but if you lose, you're not only responsible for your attorney's fees, you have to pay the government's attorney's fees. This is what they do in the United Kingdom. The reality is, this discourages protests, but it also discourages legitimate protests, and so I'm not a big fan of that either. I think the best solution is to have some kind of expert review of all incoming protests. And what happens is, at the best tribunals, where they have very knowledgeable adjudicators, they can often find the frivolous protests very early on and dismiss them quickly. I'll talk about this later, but for example, at our primary protest organization in the United States, there are 100 days to resolve protests, but most of the frivolous protests are eliminated in the first 7 to 10 days. They are reviewed by experts, and if there's no validity to them, they're eliminated quite quickly. Okay, what I'd like to do in my remaining time, and I'm going to do this relatively quickly, is just offer you some resources to show the diversity of approaches from around the world. One of the reasons I do this is to remind you that all states are different, everyone is experimenting, all states are constantly changing their approaches. But if you're interested in other models, there's a tremendous amount of information out there. Okay, so what I'm going to talk about is the World Trade Organization, the European Union, the United States, and the United Nations Model Law. I only mention the World Trade Organization because, remember, this is a globally accepted best practices document. Remember also, the WTO does not resolve challenges. They only provide guidelines for what the state should do in their domestic systems. So, they have a fundamental requirement, and what do they ask for? Timely, effective, transparent, non-discriminatory. And they say they don't care if it's administrative or judicial. Either one's fine with them. Again, same basic issues here, and the remedies, the only mandatory remedy that they recommend is bid and proposal costs. They do suggest, however, that you have to have that interim remedy of the standstill or the freeze. They have a number of additional requirements. Basically, don't punish people who bring protests in the future, have an impartial adjudication, and basically move things along relatively quickly. They have a number of basic legal requirements there, and again, these are all very skeletal, but it shows you that these are the things that most of the states around the world have agreed to. All right, let me say a word about the European Union Remedies Directive. And again, I realize the font is very small, so you may find this interesting. The European Union has a very, very good web page on their Remedies Directive, and the URL is very easy to find down here. Okay, remember, the European Union also does not resolve challenges. The European Union Remedies Directive creates rules for how each of the European states should manage their remedies system. So what they provide is a long list of mandates for how the individual states should manage their challenge or remedy systems. And as you'll see, it's a very, very long list. But here's the best thing. This is very, very recent, and I strongly encourage you to look at this. One thing the European Union realized pretty quickly is they created this remedies directive, and all of the states were doing different things. So they said, maybe we should talk to each other. So what they did is they created a network of review bodies. And so all of the review bodies in Europe get together to pool their experience, to provide model solutions, and here's the best part, they have a scoreboard. They're doing data. Remember we talked yesterday how important the data is? They're collecting data as to what everyone's doing. And so you can compare what happens when you give more time, what happens when you give less time, what happens when you give better remedies, what happens when you don't, what happens if you use a judicial forum versus an administrative forum. So basically what you have is among the various European countries, you have an ongoing comparative case study of different approaches on challenge mechanisms. Now, to be clear, the scorecard is very new, so it's not fully populated. But it's really fun to watch, and it's incredibly interesting in that regard. And again, lots of information on the European Union Remedies Directive on their excellent webpage. Okay, let me spend the last few minutes with the United States experience. I give you the United States experience for a number of reasons. We have a massive procurement system. We have a big industrial base. We're generally open to foreign competitions. And our bureaucracy and our judicial regime is fully evolved. But also, in the United States, we have a lot of lawyers. In Washington, D.C., we have more lawyers than most countries have lawyers. We have lawyers everywhere. We love to litigate. So we have a lot of experience. I'm not saying it's good experience. I'm just saying we have a lot of experience. But also keep in mind, in the United States, we have a central federal government procurement system. We have 50 state systems that are all different. We have thousands of municipal systems, and we also have regional authorities. I'll talk about this a little bit later this afternoon, but you have to be a little bit careful comparing and contrasting municipalities and regional authorities and states. For example, for those of you who know much about the United States, New York, Chicago, Los Angeles, Houston, these cities are larger than most states and larger than many countries around the world. The largest regional authority in the United States is the New York Port Authority, which runs all of the ports in New York and New Jersey, but it's also responsible for all of the big international and local airports, like Kennedy Airport and Newark Airport and LaGuardia. The New York Port Authority is larger in terms of procurement than most states and many countries around the world. But we'll talk more about that this afternoon, too. All right, keep in mind, the United States, it's imperfect, but we have a lot of information that you can learn from. In other words, you can look at what we've done wrong and do something different. Okay. The most unique aspect of the United States is we have 3 different challenge fora. And to make it even more bizarre, there's no exhaustion requirement. In other words, you don't have to go to one and then the other and the other. It's not like a trial and an appeal. We have 3 separate bodies, all in different places, all with different procedures, and you can go to them any way you choose. So you don't have to go to one first. Okay? Personally, I think this is too many. I think it's a relatively inefficient approach, but they all have strengths and weaknesses that we can learn from. Okay, let me start with agency or ministry protests. If the Department of Education awards a contract, you can bring a challenge to the Department of Education. As a general rule, what we call agency protests tend to be not very effective. Now, the advantage of the agency protest is it's very inexpensive, and there is one situation where we think they're incredibly valuable, and that is that early protest. Remember when I talked about challenges to the solicitation? I don't understand the solicitation. The solicitation is internally inconsistent. There are pages missing. I don't think you're asking for what you really want. I don't think you realize what the private sector can provide. The beauty of these early protests for error correction is very, very helpful because the government doesn't have to engage in ex-parte communication with the offerer. Now, on the flip side, the biggest problem with the agency protest is the issue of objectivity. Again, let me go back to human nature. How many of you like to be criticized? No? How many of you, when you get a letter that says, you are an idiot or a moron or a criminal or you are incompetent, immediately write back and say, you're right, I made a mistake? Okay? This is the problem. When you write to the agency and say, you just ran an incorrect procurement, the agency's immediate reaction is to say, no, I didn't. So we tweaked the system to say that the protest has to go to one level above the contracting officer or the procuring official. Now, how about this? How many of you want to work for a boss who tells you you're wrong and doesn't stand up for you when you're criticized? From a management standpoint, it's very hard there also. So, as a general rule, this is a difficult situation, but it's inexpensive and it's very, very useful for early error correction protests. Okay, next. In the United States, you can go to the judiciary and bring a challenge. This does not work very well. In the United States, the courts are too expensive and too slow, but much more important than that, the biggest problem with the court is they don't know enough about procurement. They simply aren't in a situation where they can get over the hump in terms of the learning curve to provide that kind of expert advice. So, statistically, we have found that far less than 10% of all protests go to our federal court, and in fact, in many years, it's closer to 1%. The large, sophisticated firms never go to the court because they think it's a waste of money. Having said that, some protests go to the court for large and important cases where they think that there's going to be a need for additional discovery. But again, at least in the United States, we have found this to be a not very effective solution. Our most popular solution, and one that's often used as a model around the world, is our GAO, or our Government Accountability Office. It's a unique forum because it's located in our legislature, but it's fully independent. Their mandate is to be independent, fast, and cheap or inexpensive. They have a lot of experience, and their decisions have created a uniform body of law that we use for training and for knowledge purposes. They are highly transparent, and their rules are very, very familiar, but I'll go back in just a moment to show you how transparent they are, because their goal is to be accessible not only to big businesses, but to small and medium enterprises. If you go to the GAO webpage, and here's the URL right here, www.gao.gov, they have all kinds of online tools so that anyone around the world can figure out how the process works. You can file electronically, you don't need an attorney, it's very, very easy. But in addition, they even have a 7-minute podcast where you can just push the button and they'll tell you how everything is supposed to work. They created an electronic filing system a number of years ago, and to pay for that, they created a filing fee of $350. It's not tied to the amount of the protest, but that paid for the electronic filing system. But again, all work with GAO can be done electronically. You don't have to go to Washington, D.C. In addition, they have been publishing for decades what they call a descriptive guide. So there's a simple document that they publish regularly, and it's on the web, that tells you everything you need to know to walk through the process. And every few years they update it. It's currently in its 10th edition, but it's written so literally anybody could understand how the system works. The things that make GAO popular: the moment you file at GAO, electronically or with a stamp, the process stops. The process stops automatically for 100 days. The people who resolve the disputes are very, very talented, knowledgeable, but they're respected because there's almost no turnover, the jobs are hard to get, and everybody knows who they are. They've proven time and time again that they're independent and knowledgeable. The moment the protest is filed, the government must create an agency report where they give all of the relevant documents, including the contract file, to GAO and to the challenger. It speeds the process along and it saves money. There is some discovery and there can be live witnesses, but it's not done that often, and you can work at GAO with or without an attorney. Now, what we've seen over the years is the volume fluctuates. The largest volume of protests we ever had in 1993, we had more than 3,300 protests that year. It's gone down, it's gone up, it went down a little bit last year. But nonetheless, we consistently see our legislature coming up with suggestions for how we can tweak the process, maybe giving GAO less time or making the loser pay. But we haven't done any of those things just yet. All right, the last one I want to mention is the United Nations Model Law. And I mention this because, not necessarily because the United Nations Model Law is so valuable, but it does reflect globally accepted best practices in challenges. You can get the model law on the internet. The URL is easy to find. And the challenge proceedings are on page 66. But better, when the model law was published, the United Nations put together a guide to enactment. And they have a 30-page description of how the challenge processes should work. And this, again, is a very, very helpful resource. Okay, I've been talking for a long time. I don't know, should I take questions or not take questions? Okay, no questions now, but again, I'll be back this afternoon. Okay, I'll turn it over to you. Thank you.